Welcome back to the Constitution Line by Line. I'm Senator Mike Lee, and today we'll be concluding our discussion of Article 1, Section 7, with Clauses 2 and 3. The text of this provision reads as follows, quote, "Every bill which shall have passed the House of Representatives and the Senate shall, before it becomes a law, be presented to the President of the United States. If he approve, he shall sign it, but if not, he shall return it, with his objections to that House in which it shall have originated, who shall enter the objections at large on their journal, and proceed to reconsider it. If after such reconsideration 2/3 of that House shall agree to pass the bill, it shall be sent, together with the objections, to the other House, by which it shall likewise be reconsidered. And if approved by 2/3 of that House, it shall become a law. But in all such cases, the votes of both Houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each House respectively. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law, in like manner as if he had signed it, unless the Congress, by their adjournment, prevent its return, in which case it shall not be a law. Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill. This is the meat of the legislative process. If you saw that old cartoon in school about how a bill becomes a law, this is what they were talking about. These clauses specify the President's role in approving legislation passed by Congress and the conditions under which Congress can override a presidential veto. While Article 1, Section 1 specifies that Congress is the only body capable of crafting and passing federal legislation, Section 7 expands on this provision by adding additional detail about how the mechanics of the process actually work. As part of the system of checks and balances established by the framers, the President has to approve legislation before it can become law, unless 2/3 of the Congress votes to override his veto. This provision exists to ensure that a president can't gain undue power to prevent Congress from doing its job through unreasonable or excessive vetoes. However, given the difficulty of obtaining a 2/3 consensus in the legislature, it's rare for a Congress to be able to railroad an unwilling president as well. In our nation's history, a presidential veto has been overridden only 112 times. Now, this usually occurs only once or twice per presidency. But in the aftermath of the Civil War, with the White House and Congress deeply divided, President Andrew Johnson saw his vetoes overridden a whopping 15 times, more than any other president. At a time when we've seen a great deal of disagreement between congressional leaders and recent presidents, this portion of Article 1, Section 7 is important in clarifying how these two branches are expected to work together to craft laws. As the executive branch has increased in power over the years, Section 7 remains relevant in providing Congress a way to rein in a president who is exceeding his authority and to retain the body's legislative power established in Article 1, Section 1. Note that the president is restricted here to either approving or disapproving of legislation. It's a binary choice. While he can consult with congressional leadership and make suggestions, he has no formal power to insert or remove provisions of a law. All he can do is vote up or down. From time to time, this restriction has been called into question, especially by those who worry about the tendency of Congress to smuggle controversial or partisan provisions into must-pass funding bills. The practice known as log rolling, where members are induced to vote for legislation by the insertion of special carve-outs for their states or pet funding projects, is also a concern. It's easy for the president to feel manipulated into approving a bill that he doesn't agree with in order, for example, to prevent the federal government from shutting down. In 1998, a fix to this problem was proposed in a bill that would have given the president a line item veto. In other words, he would be able to veto parts of the bill while approving the rest. This bill was struck down by the Supreme Court in a case called Clinton versus City of New York. The court reasoned that the bill would have given the president the de facto power to craft legislation, a power specifically denied the president under Article 1, Section 1, and Article 1, Section 7, and ruled that the line item veto would specifically violate Section 7's description of the veto process. While Section 7 gives the president the ability to veto legislation, the process does not work the other way around. In other words, Congress does not necessarily have the authority to veto actions taken by the executive branch, provided that those actions are themselves constitutional. This was demonstrated in the case of Immigration and Naturalization Service versus Chadha in 1983, when the House of Representatives attempted to legislatively veto an order by the Attorney General to suspend the deportation of a Kenyan immigrant. The court ruled that the legislative veto violated principles of bicameralism, in which the House and Senate are required to work together to pass legislation, and that they also violated Article 1, Section 7, which provided for no mechanism for a legislative veto. You see, what had happened is that between the Franklin D. Roosevelt administration, when the legislative veto provisions first started making their appearance, and the Reagan administration, when INS v. Chadha was argued, the use of the legislative veto had gone from something that was isolated and sporadic to something that was relatively continuous and systematic. It was something that Congress started doing all the time. And so this really did represent a pretty fundamental shift in how legislation was crafted. It's especially significant when you look at the fact that had INS v. Chadha been decided differently, not only would you have seen legislative veto provisions already enacted to remain on the books, but you probably would have seen something of a proliferation of more and more of these provisions. Congress would delegate broad power to the executive branch, but then keep its foot in the door by reserving the last right to say, no, we don't like that. This in turn would have led to even more flagrant and continuous violations of the presentment clause. And so, look, the Supreme Court's ruling in INS v. Chadha, while criticized by some, was really a significant victory for the separation of powers, because it drew a line in the sand and recognized a distinction between legislation and executive action. If you're going to change the law, if you're going to change the legislative status quo in America through federal law, you have to operate within the confines of Article 1, Section 7, including the presentment clause. You can't get away from that. Finally, there's an interesting legislative tactic embedded in Article 1, Section 7, known as the pocket veto. If the president neither signs nor vetoes a bill within 10 days, and the Congress adjourns during that time, the unsigned bill is effectively vetoed, and there's no mechanism for Congress to vote to override it. This remains a controversial practice, and there have been several legal challenges attempting to clarify what constitutes an adjournment for purposes of a pocket veto, such as the pocket veto case in 1929 and Wright versus United States in 1938, which found that both houses of Congress must be out of session to constitute an adjournment. Thank you for joining me for this episode of the Constitution Line by Line. Next time, we'll begin our discussion of Article 1, Section 8, which lists the kinds of laws Congress is permitted to pass under a system of limited government. Make sure to subscribe to the channel and to click the bell for notifications, and I'll look forward to seeing you there.